Defense strategies to use in a personal injury case. If you are considering filing a personal injury case, it may help you to be aware of the kinds of defenses that the other party, the defendant, may use so you can prepare yourself. If you are the defendant and another party is claiming that you are liable for causing their injuries, you may wish to use some defense strategies that could help you avoid liability and win the lawsuit. Defenses in a personal injury case are likely to relate to what the plaintiff, the injured party, did in relation to the accident. This includes how the accident was caused, and what role they played in causing the accident, if applicable. And what the plaintiff did not do after they were injured, such as filing their lawsuit on time and getting medical help. The accident and the plaintiff's role. When a personal injury lawsuit is filed, one of the arguments that the defendant or the defendant's lawyer will make is that the plaintiff was partially at fault, or completely at fault for their accident that caused their injuries. This is usually the first argument given. If you are partially to blame, it is likely that any compensation you receive will be affected. It is likely that the defendant will argue this quite early on in the case if the plaintiff decides to settle the case with the defendant and an award, or settlement, is drawn up. In some cases, the defendant will argue this at the end of a very long trial in which a jury reaches a find about who is liable. The jury will apportion fault among or between both parties, and the award may reflect how much the plaintiff was at fault for the accident. Comparative negligence. If the judge or jury finds that the plaintiff was negligent, they then have to work out how negligent the plaintiff was in comparison to how negligent the defendant was. For example, the judge or jury may find that the defendant was 75% negligent, and the plaintiff 25% negligent for the plaintiff's injuries. This means that the plaintiff was 25% at fault for their injuries. If it is found that the plaintiff was completely at fault for the accident that resulted in their injuries, they may not recover any settlement at all, and their compensation claim may be denied. One of the most important things that needs to be understood in comparative negligence cases is that the plaintiff's negligence will affect the amount of compensation they receive by their percentage of fault. However, different states have different rules for comparative and contributory negligence cases, and may, therefore, award as they see appropriate. Comparative negligence, the different types. As can be seen in the article How Does Comparative Negligence Affect a Slip and Fall Claim?, many parts of the United States follow a comparative negligence rule that works to calculate the damages under a specific formula, looking at every party's degree of fault. If, for example, you were found to be 50% at fault for an accident, any compensation you receive is likely to be reduced by 50%. This means that if the damages add up to $15,000, it's likely that you will only receive $7,500. However, many states fall into two categories when damage awards are calculated. These categories are modified comparative negligence and pure comparative negligence. Modified comparative negligence: here a plaintiff is able to claim compensation if they were only 50% or less responsible for the accident. Some states require that the plaintiff is less than 50% responsible for their accident. Pure comparative negligence: here a plaintiff can receive damages regardless of how much they were at fault. Contributory negligence. In some of the states that follow this type of negligence, plaintiffs who are found to be even slightly at fault for their injury may not receive any compensation as part of their personal injury case. Even if you found to be just 5% at fault, you would not receive any damage for your claim. Contributory negligence. Contributory negligence laws are not quite as forgiving as that of comparative negligence laws. This is because in the states that do follow contributory negligence laws, victims who are only partly to blame may not get any compensation. The good news is there are only 5 states or jurisdictions that have the contributory negligence law. These states are Alabama, District of Columbia, Maryland, Virginia, North Carolina. Assumption of risk. In some cases, a defendant who is facing a lawsuit may argue that the plaintiff assumed the risk, knew that there was a chance they could get injured, by participating in a risky or dangerous activity such as parkour, or walking down stairs that they knew were not stable. This type of defense is raised in many lawsuits, particularly those that involve a plaintiff who played or watched sports. A key feature of the assumption of risk is that the injury must be related to the risk that is involved in the activity. For example, if you were playing baseball and you were hit by the ball, the defense is likely to claim that you assumed the risk of injury because it's the type of injury that occurs in baseball. This ultimately means that the plaintiff is very unlikely to win the lawsuit. However, if you were playing baseball and one of the signs fell off and hit you, the defendant could not argue that you assumed the risk because a falling sign is not a danger that's connected to playing the game. Arguments the defense may use. The defendant in a personal injury case may do what they can to get the case dismissed or to reduce the amount of compensation they will have to pay out. To do this, they need to make some arguments that they hope will help them to win, even though the arguments are not always the best defenses to use. The lawsuit does not, or fails to, state a claim. The defendant might argue that the plaintiff's allegation does not establish an essential element. What this means is that a part of the plaintiff's negligence claim, for example, does not include the element of causation. Causation is a vital link between the injuries that the plaintiff sustained and the defendant's actions. If the lawsuit does not illustrate a very clear link between the accident and the defendant's actions, then the defendant may be relieved of liability for the injuries sustained by the plaintiff. For example, if the plaintiff was walking along a tiled floor and they fell and injured themselves, the defendant could argue that there is no link between the fall and the defendant. However, if the plaintiff mentions they were walking along a tiled floor and they tripped on a broken tile, the defendant may not be able to say that there was not a link or causation. The lawsuit failed to file the lawsuit on time. Occasionally, defendants may claim that the plaintiff did not file the lawsuit on time. In other words, it did not adhere to the Statute of Limitations. The Statute of Limitations refers to a state law that gives the plaintiff a specific amount of time to file a lawsuit. If a state's Statute of Limitations gives the plaintiff 1 year to file, but they file after 1 year and 1 month, the defendant could argue that the plaintiff has missed the deadline and the lawsuit should, therefore, be dismissed. Please read our article "The Statute of Limitations in Slip and Fall Cases" for more information. The plaintiff failed to mitigate damages. The defendant can argue that any compensation they have to pay to the plaintiff should be reduced because their action, filing the lawsuit, made the damages even worse. This means that if the plaintiff should have gone to the emergency room right after their accident so they could minimize the amount of damage or injury that has been done to them. However, if the plaintiff waited a few weeks before receiving medical help, their injuries could have potentially become worse, and therefore their medical treatment would have cost more. The defendant may then argue that the court should reduce the amount of compensation they have to pay out because the plaintiff failed to mitigate damages when the extra expense could have been avoided should they have sought treatment right away. If you are considering filing a personal injury case, it may help you to be aware of the kinds of defenses that the defendant may use so you can prepare yourself should they make these arguments.